Good afternoon and welcome back. My name is Andrea Carlevaris. I am the Secretary General of the ICC International Court of Arbitration, and I have the pleasure to moderate this next panel, but also the big challenge of moderating this panel. Challenge for various reasons. First of all, this is the first panel of the afternoon after a good lunch, and the risk of dozing off is always very, very high. Second, this follows Judge Greenwood's excellent presentation, so it will be difficult to keep the level sufficiently high, but I'm sure we'll try our best. And third, we have only 1 hour, and we are already running late since the beginning, with 5 excellent speakers. And on top of this, I think the topic we have for this panel is an excellent one, effective deliberations for arbitrators. We will be dealing with this topic in a broad sense, focusing not only on the deliberations, stricto sensu, which of course concern only the end of the case and the arbitral tribunal, but more broadly, trying to consider all, time permitting, of course, all ingredients of effective deliberations and how deliberations can be facilitated by the way the case is pleaded, presented before the actual time of deliberations come, and the contribution that all actors in the process can give in achieving the goal of effective deliberations. The various actors in the process are represented in this panel, the arbitrators, of course, but also counsel and also the institutions. So after setting the scene with some introductory remarks on what are arbitrators' expectations, we then go through the various procedural steps and see what role those expectations or the parties' perception as to what the expectations of arbitrators are can play. As I said, we have an excellent panel, and a proper introduction of each of the members of this panel and of their impressive titles and background would probably exhaust all the time of our disposal, so I will refrain from doing this, and I will confine myself to a very short presentation. To my immediate left is John Townsend. John is a litigation partner in the Washington, D.C. office of Hughes, Hubbard and Reed, where he chairs the arbitration and ADR practice group. Needless to say, John has a huge experience as counsel and as an arbitrator, both in international and domestic disputes. And he served as chairman of the board of directors of the American Arbitration Association from 2007 to 2010, and as chairman of the executive committee of the AAA from 2004 and 2007. Next is Clara Brillenburg. Clara is a partner at Foley Hoag in Washington, again, where she specializes in advising sovereign states in international disputes, both state-to-state and investor-state disputes. She has, of course, extensive experience, in particular in ICSID arbitration. Next to Clara is Mohammed Abdel-Wahab. Mohammed is the chair of the private international law and professor of international arbitration at the Cairo University, and he's also the founding partner of the firm Zulfikar and Partners. He is a vice president since July this year of the ICC International Court of Arbitration, and he's also a member of the LCIA. We then have Kevin Kim, who's the head and founder of By Kim and Lee in International Arbitration and Litigation Practice Group based in Seoul. He's acted as counsel, presiding arbitrator or sole arbitrator in numerous cases under various institutional and ad hoc cases. Kevin is also a vice president of the ICC Court of Arbitration and a board member of the AAA and the member of the panel of arbitrators of ICSID. And finally, we have Janet Whittaker, who's counsel at Simpson Thacher and Bartlett, where she in particular focuses on international arbitration and litigation. And before joining the firm, Janet was served as legal counsel at ICSID. So as I said, we will try to cover various procedural aspects from the perspective of how to best contribute to the eventual deliberations of the arbitrators. As you will see, the panel will be organized in a very informal way, so I will just invite the members of this panel to give some introductory remark on the various topics, and I then look forward to hearing from the other members of the panel about these aspects. So I will start with John Townsend. As I said, it will be interesting to know in general what are the arbitrators' expectations from the parties when it bearing in mind the goal of effective deliberations. John.
I hope not to be bored. Is this on? Beyond that, we're really dealing with Advocacy 101. A counsel faced with 3 arbitrators has to remember that it's different to argue to 3 people than it is to 1 judge. It's also different than arguing facts to 12 jurors. You have to take into account in crafting your case that you have 3 decision makers who are going to talk to each other about both facts and law. And so you need not only to sway them individually, but to give each of them the material to defend whatever view they've come to from assault by the other 2. So let me just venture a few thoughts on how to do that for lawyers. First, I think foremost key, tell a good story. You need to put your client's case in a form that the arbitrators will remember when they get to deliberations. And it can be a long leg, especially, as someone pointed out this morning, if there are post-hearing briefs. You can have, and if you have rounds of briefing before hearings, the case can go on for a couple of years. And your case is probably almost certainly not the only case each arbitrator is dealing with. So while it is right in the center of your mind at all times, while you're fully immersed in it, while your client is passionate about it, and you are reporting to your client every day on the latest thing you have found in the file, the arbitrator has got 6 or 7 others, if not 15 others, on his or her mind, and you need to grab them. So you need a story, because human beings remember stories better than they remember facts. So they need to remember, this is the case in which this happened. So get it out there, get it in the paper, get it in the oral presentation, get it in your summation. It's the organizing principle on which you hang everything else. Having given them that, though, that's not going to do it. You may grab them at the beginning, you may give them the sense, gee, that sounds like these guys ought to win. But when the arbitrators sit down to talk to each other and sit down to write an award, the story alone won't do it. You may get their sympathy, but you're not necessarily going to get the award if you don't give them the backup. And you have got to give them first the facts. Arbitrators decide most cases, in my experience, on the facts. And having decided how the facts ought to come out, they then figure out what legal theory justifies the decision. But I'm firmly convinced that 80% of cases turn on facts unless there is simply an absolute rule of law that would get a case dismissed in court. So you need to give them the facts in sufficient detail so they are comfortable that your story is the one that explains the facts, but not in so much detail that their minds completely fuzz up. I sat in a case in London a couple of years ago where when we sat down for opening arguments, and this was a very long, very big case, and we had English lawyers on both sides, so of course we had skeleton arguments when we sat down for openings. And one side's skeleton argument was 600 pages long. There's no way, absolutely no way, the arbitrator is going to absorb that, especially at the beginning of a case. So you have got to not only give them the facts in enough detail to make it compelling that the story you are trying to sell is the story which explains the facts, but also pared down enough so that the average human mind, and with luck you're dealing with a better than average mind with the arbitrators, but not always. The mind has to be able to absorb them in an ordered way. So you've really got to cut the case down to what matters. And then you've got to back it up with law that tells them that the decision they want to reach, that you have persuaded them they ought to reach, that you have persuaded them is the just result, is consistent with the law they have to apply. And if you can equip them with all that pretty much in that order, in digestible form, not in such huge volume that they cannot remember at the end of the brief where they started at the beginning, then you've probably got them. And with luck, you will have each of them, and they will compare notes, and the notes will come together. And most arbitration awards are unanimous. So, most arbitrators reach, there may be some trade-offs of, well, this one thinks the damages ought to be higher, and that one, wants to make a pronouncement for future generations on a legal issue. But most arbitration tribunals come together on a decision. And if you tee it up that way, if you give them the compelling story that fits the facts, backed up by the law, you will get them unless you have failed to arm them against what's coming from the other side. And that's what the last point I would urge is face the hard questions. Anticipate where the adversary is coming from and give the arbitrators the equipment they need not to be impressed when they hear that. You've got to confront the tough arguments coming from the other side, because there always is another side. I've never seen a case that couldn't be argued both ways. And the challenge is to make your side compelling, but in the process of doing that, to equip the arbitrators to discount or simply decline to accept the arguments that are becoming from the other side. With that very, very superficial overview, I pass it on to my colleagues.
So tell a good story that the arbitrators will remember, try to catch their attention and anticipate difficult questions. Any reaction from the other members of the tribunal? Is this what indeed you have in mind when you present your case?
I think that we've heard multiple times today that simplicity is key, and I think trying to come up with a clear narrative that takes you from beginning to end, situation, complication, question, answer, or something along those lines, is a good way to cut out the fat and keep the story simple.
Okay, let's try to move some more into some more concrete aspects and procedural aspects. Written pleadings. Mohammed, is there any particular thing to bear in mind? What are the main considerations at that stage?
Now, given I've been assigned the topic of written pleadings and evidence, which is always challenging to appear before such a distinguished crowd in 10 minutes and say something that is useful, it's very difficult. But given that our panel is entrusted with effective deliberation, I would opt for an approach of reverse engineering. So what I'm going to say is in hope of reaching effective deliberations. And to that extent, I'm not going to address form and content of written pleadings because most of the people appearing before me are even much more experienced or have their own style, which works out very well. But what I'm interested in are a number of areas that we rarely stop at or consider carefully. And I think we ought to spend more time considering those matters, especially in light of John's excellent point about the story-oriented outcome or result, and what is the role of law in this regard. Now, in relation to form, structure and organization is, of course, a matter of style, but what I'm interested in, and I see increasingly international arbitration, specifically in investment and in other sort of international commercial disputes, is language and translation. It is very interesting, and I see a profound impact when arbitrators do not speak or read the language of certain piece of evidence and document, how counsel could transform one word or change the translation that may affect and impact the outcome. I've seen that quite frequently in cases, and there's always the awkward moment when counsel for both parties present a translation that is distinct from the other, and it could go either way, whereas the original word in the language can only bear one connotation. So that's an area that people rarely look into and consider carefully. Nevertheless, it does impact the outcome in many cases. The other thing is the integration of facts and law. Storytelling, of course, is very important, but storytelling is one thing, and facts is another thing. I mean, because the story could fit in very well, and the facts do not serve that story. So how to establish the facts, what evidence could be put forward in terms of supporting legal arguments, principles. And to that effect, one of the questions that people do not take a considerable stand on is the extent of disclosure or legal counsel's duty to disclose legal principles in one way or the other. So, for example, if you're counsel in a certain jurisdiction or under a certain applicable law, are you required to disclose all legal precedents or principles regarding this matter, whether they serve you or not? Or should you only disclose matters or principles or law or precedents that only serve your case, and then the burden shifts to the other party? Which then brings me to the point of the burden of proof, who bears the burden of proof, and the common and civil law dichotomy in this regard, whether it's a strict standard of proof, circumstantial evidence, preponderance of evidence, and in addition to that, to the burden of proof is the standard of proof that is required. And then, is there any room really for the theoretical concept that is advocated in several doctrinal writings about negative inferences when one party refrains from stating the opposite argument or producing a document that it's required to produce? There's always this argument about production of documents. Now, that said, and with all these matters into consideration, whether in relation to evidence, the interplay between law and the facts, one should wonder how to make deliberations more effective. Now, John has rightly mentioned skeleton arguments, which is more or less a common law feature and is used in many cases. Now, is that the time to consider that maybe we could look into a new concept of skeleton queries or skeleton issues, where the arbitrators, before the hearing, would circulate a skeleton of the issues or queries that they would like to hear counsel on. Now, of course, that is quite interesting because it may give the parties an inclination about the arbitrator's predisposition, but a skillful arbitrator would know how to draft that, which often happens after the hearing for post-hearing memorials if you have tribunal questions. But serving this before the hearing would first ensure that the parties and counsel are on board about the important issues that the tribunal expects to hear the parties on, would bridge the gap that is often schizophrenic. When you sit as an arbitrator, you wonder, what is counsel saying? They don't know the case. These are not the issues that are decisive in the case. And then counsel, on the other hand, looks at the arbitrators. These people did not read the file. They're asking the wrong questions. They don't know what they're saying. So having this sort of proposal for a skeleton issues or skeleton queries could bridge this gap, prepare everyone for the hearing, which could be very effective for the deliberations that could be subsequent. I mean, it's a simple proposal. It might work, it might not, but I'm just suggesting that. Thank you.
So, picking up on this, John, is this something, do you spend time at the beginning of the case discussing with counsel, with parties, what your expectations are, and for example, discussing proposals such as the one Mohammed just put forward?
I think that has to be done very carefully because the easiest way for arbitrators to lose the confidence of the parties is to appear to have jumped too quickly to a conclusion. So I think you need to allow the parties and their counsel some space to develop the case, to get it in front of you. It is unlikely to all be in the initial papers, especially if you're dealing with a set of rules where you have a fairly short notice at the beginning of the case, and you don't get the full exposition of the party's case until months into it. So I'm a firm believer in asking clarifying questions from the beginning, but I would be very hesitant to try to say, well, it seems to us that the case turns on these three questions early in the case. Once you've got full pleadings from both sides, especially once you've been through an oral hearing, at that point, then I think it's very fair and very helpful to counsel on both sides for the tribunal to, and I think it's often a good idea to ask, would you like before final argument or before the post-hearing brief to know the questions on the tribunal's mind? And counsel almost always say, yes, we sure would, and as counsel, I welcome that. At that point, well into the case, then I think it's valuable and it helps focus, with luck, the final arguments.
Talking about hearing and oral presentations of the case, Clara, what are the relevant considerations?
Well, I have 3 points on how to effectively organize a hearing. My first suggestion would be that I think it is more effective to set the hearing on a chess clock rather than having predetermined specific time frames for each phase, opening, cross-examination, etc. This forces the parties to be much more strategic, more efficient, and to focus on the issues that really matter, which then give the tribunal a better perspective on what are the core issues that are really in dispute. The second point I would say for more effective hearing organization is the more the hearing parameters are laid out further in advance by the tribunal and between the parties, the more effective they will be. Some ways that this can be done, one, for example, would be setting out the basic elements of a hearing that are common in most hearings in the tribunal's first procedural order. The parties have less of a strategic play at that point. They don't really yet know who their experts are and how their witnesses will be, and are more open to taking principled perspectives on the issues. And it also lays down some of the issues that could cause a dispute later on. Another way would be to schedule pre-hearing conferences well in advance of the hearings in order to push the parties to work together better, to air out their disputes, and to allow for those disputes to be resolved with adequate time to implement them in the hearing. One example of how this plays out into a more effective hearing is that if you can have the parties agree on which witnesses will be called far in advance of the hearings, you can avoid, for example, parties calling all of the witnesses as a precautionary defense against the other party doing the same. My third suggestion or point is something that tribunals can do both at the beginning and at the end of hearings to make them more effective. On my first suggestion at the beginning of the hearings, I'm very glad to see I find myself in good company with Mohammed and Judge Greenwood, that it would be very helpful for the tribunal to advise the parties of the issues that they would like to be addressed during the hearing. And I would note that as counsel, I do see a difference between saying these are specific questions that we would like you to give specific answers to, which perhaps parties can read into, perhaps that too narrowly confines the issues at the beginning of the hearing when things haven't been aired out, and simply listing the key issues that the tribunal would like to be sure they hear about during the hearing, and then more refining them into more detail in questions later on. This again focuses the minds and the arguments of the parties on the issues that matters most to the arbitrators. At the end of the hearing, in as much as the tribunal is able to, I think it's very helpful if they're able to schedule half a day, a full day of a deliberation immediately following the hearings, immediately following the closing, if there is one, and I know that's a topic for discussion. This helps both in terms of substance, because the issues, of course, they're most potent and the most fresh in the arbitrators and the parties' minds at the very end of the hearing. And you lose that tremendous opportunity to take that knowledge and distill it into a plan of action if you disperse to your various airports and airplanes. And it also helps in terms of process. Most arbitrators are very busy, and having the opportunity to have them all sitting in a room focused on the same issues and laying out the next steps in a very deliberate way help make the deliberation and the hearing process more efficient and hopefully lead to a swifter award.
Mohammed.
Yes, I mean, just one thing to add, maybe to clarify. We know that there is a procedural agenda for the hearing where we allocate time, whether it's chess clock or others. But what I'm suggesting is that why not have a substantive agenda? The parties who are familiar with skeleton arguments, these are the defining outline for the hearing. So the counsel, when you have counsel, the fear is always, will the arbitrators be prepared with the file? Will they have read the case? Do we have to explain everything from scratch? Should they wait until the post-hearing to start reading into the case? Now, all these practices, which I say are not good practices in arbitration, have spurred the debate about the efficiency of the process. Time is very precious. To ensure that everyone is on par, the idea of a substantive agenda would take on board not just the skeleton arguments by the parties. The tribunal is not asked to, or is not telling the parties these are only the issues. The case hinges upon those issues, although we know very well that even with the lengthiest of cases and submissions, there are defining elements for every case. So if the tribunal would share with the parties not their perception, but what they want to hear from them about these matters, this doesn't mean that others are trivial, but they want to ensure that on the substantive agenda, both parties will be heard on this. Because sometimes you come counsel arguing a case one way, focusing on points, and then the opposing counsel is in a totally different island, arguing things in a different way, and then the tribunal is faced with almost two cases and asking questions, and it falls down to a post-hearing with queries to each parties. Now, to ensure that the tribunal is prepared, the parties are prepared, making the most efficient and effective use of time, maybe it's time to consider what a substantive agenda could look like. That was the whole purpose.
Janet, do you want?
Sort of going to what Mohammed was saying, I think it's important to maintain some flexibility during the hearing as well, that you can certainly outline issues at the outset, but the reality is that cases evolve, including during hearings, and tribunals speak during breaks. And I think there's a lot of room there to continue to direct where the case is going during the course of the hearing, as well as at the outset and perhaps at the end.
Kevin?
Somewhat different aspect of hearing is the length of the hearing. So I found that some hearings continue for 3 weeks. That's quite normal in certain jurisdictions, but I don't know how in that jurisdiction the counsel can stand for a whole day and sustain for 3 weeks, but it's not helpful, it's not efficient, it's not actually the best way to present a case. So I found that no more than 10 days is efficient and useful, and I think we have some, rather than code of conduct, we might have some human rights issues of associated working on the case. So whenever we explain something to others, I understand there are certain things saying that 70% rules. That means that unless the person is listening understand already 70% of what I'm going to say, they have no way to understand properly what I'm saying. So the level of understanding is quite important. It's by time goes by, I try to understand case more in correct ways. But we have to have certain limitation. So at one time, not more than 10 days, and then if you have more than 10 days, have another time to hear the case.
I'm afraid here we are treading on a delicate cultural ground. I'm not sure that all of the members of the panel, in particular those who have a common law background, would agree that anything beyond 10 days would be too much.
I agree. It's a rare case that you can't present in 10 days. I mean, 10 is long.
I agree with John and Kevin's suggestion. In major construction cases and the like, you've got a lineup of witnesses, hundreds of claims, but honestly, 3 weeks. People end up usually using much time less and taking breaks during that interval. So it's quite interesting, and I think 10 days would do it.
Excellent. So we have a consensus. No more hearings longer than 2 weeks. Excellent.
As counsel, I'd like to reserve the right to ask for more than 10 days.
Let's move on to the phase after the hearing. Normally there is this dilemma between post-hearing briefs, oral closing arguments. Kim, your views?
Yes, I hesitate to say that I oppose the idea of post-hearing brief, but I got the green light from Judge Greenwood. Actually, to me, he's very green, so it's many things I agree with him. I always prefer interactive discussions or arguments together with tribunal rather than just one-way submission. When you have post-hearing brief, of course this is basically case by case. There's some cases quite straightforward that you can have post-hearing brief might be more efficient. But without knowing how much the tribunal understands the case and what the body position of the other side, we end up with a lot of sayings in the written submissions. Written submissions, we recently exchanged with one of my friends sitting here. We exchanged more than 800 pages of submission one time. Our intention is that we don't want tribunal to read the 800 pages. When you give the Bible to others, you're not supposed to, the person not supposed to read the whole Bible in one. But we are going to refer the particular part of the Bible when I want to address the point. After hearing, probably, or in the course of the hearing. So maybe you have some skeleton submissions and with some oral explanation before the tribunal, and then tribunal asks questions and answer to that question. That will be much more efficient than just written submissions. So people are just worried about scheduling things. So again, it's it's all related to the length of the hearing. 3 weeks straight, then you can you just worry about if you have 3 different hearings, then it's quite more difficult to the scheduling. But if you have a shorter period, then it's more easier to find a free time for 3 arbitrators. So closing maybe for 3 days, 2 days closing arguments is much more efficient than post-hearing brief. I finished 10 hearings on the merit this year. And among 10 cases, only 1 case we agreed to have oral closing rather than post-hearing brief. 9 cases, among 9 cases, 8 cases we agreed to have 2-round post-hearing brief. So it's just like competing, how many associates you have, how many legal staff you have to work on the case. And another point is that lead counsel have less time to review carefully all the details of post-hearing brief, while the oral arguments is different. It's the person to present the case, he will pay more attention to the case and to see whether this argument is really persuasive or not. Another point you might want to, I want to add in the post-hearing stage is that if the tribunal have assistant, we pay attention to that point as well. I always describe that tribunal as students, in a class. They always say that I read documents, I'm going to review the documents, I'm going to start this point, I already understand the point, nodding heads. Actually, it's hardly to review document carefully. they normally misunderstood a very, very important point. When they have a private tutor, so you have to consider that private tutor is an important person to understand the case. So I would rather that person attend the hearing and see what happens at the hearing, and also follow up to all the developments after that. Otherwise, when they have a hearing and they have a deliberation after 1 year after hearing, then everybody forget what happens, and then that assistant mostly based upon the documents, so that the brief made by that assistant will have impacts on the tribunal's decision. That I really want to avoid. So I would propose that if it's a complicated case, that we want some skeleton submissions and oral arguments at the closing would be much more efficient than the posting brief.
Sorry, Kevin, two quick follow-up questions. One on precisely oral arguments. When? Immediately after the hearing, the evidentiary hearing?
That's a very important point. In commercial arbitration, we sometimes do that closing argument just after the hearing, because before the tribunal, it's terribly important to have that argument or closing arguments before tribunal have deliberation. So we just follow up the closing arguments at the end of the hearing might be efficient, but investment treaty arbitration, I found that it's almost impossible, because you have to fix the transcript, and you are dealing with many witnesses and legal expert and economic expert and other experts, and the lead counsel have no time to digest everything and prepare the closing arguments. And it's not efficient at all, because tribunal also need to understand many things. So I propose closing arguments sometime after the hearing, a close of main hearing, and then the tribunal also set some deliberation time after that. For the deliberation, I always insist that the tribunal must disclose when they are going to have deliberation and where they are going to deliberation. Parties is entitled to know when they are going to have deliberation, because it's very, very important that when we are going to make a proper argument at the point. So if the tribunal just notified parties that we are going to have deliberation at a certain date, so before the date, we set a certain day, make an oral presentation before the tribunal.
We'll come to the time of deliberations, but on post-hearing briefs, what are they? Are they, let's say, a guide to effective deliberations, so precisely indicating to the tribunal a suggested path for the decision, or are they comprehensive and exhaustive summaries of the case? In which case, I wonder if the skeleton argument is 600 pages, what post-hearing briefs should be.
If the parties decide have the post-hearing brief, tribunal attempted to say that it's the page limitation. I don't like page limitation as counsel. I don't like the page limitation even as tribunal, because when you have many things to say, it's parties entitled to say many things there. But more important thing to help the tribunal is that the reference of the particular evidence, and together with the argument you're making, so the format of submission should be liberal, much liberal than the other submissions. So I would propose the parties are free to submit whatever they feel is useful to the tribunal. Could be the chart format or the PowerPoint or whatever is useful to the tribunal can be adopted.
Mohammed, do you have a comment on this?
Yes, I mean, I just find Kevin's idea of a two version of a Bible where we don't know the truth is 800 pages that the tribunal is not required to read, and you as counsel expect that. Quite interesting, because I had a hearing last week where counsel, and that's one of the sins when people appear as counsel have not studied their case very well. A party has put in one of the submissions in a paragraph a challenge to the tribunal's jurisdiction, which was not seen by the opposing counsel. And when I read that, I posed the question during the hearing, and counsel's immediate answer was, "Oh, you really read that?" And that was shocking, because then the tribunal will go in their retreat, in their seclusion. They have not heard the parties on a jurisdictional challenge embedded in one of the paragraphs that they were not expected to read, which they should have read. And then I asked him, what is the purpose of that challenge? And he could not give an answer. He said, well, we did not expect that the tribunal would read that, but we will address that in our post-hearing submissions. So I think that is one of the serious problems when tribunals do not come prepared, when counsel uses the process in a way to keep a door open for subsequent challenge if the tribunal does not take note of that. So it's very interesting. I would expect that if counsel was to serve 1,000 pages, the tribunal would be expected to read them. And that's why sometimes page limitation is useful. When students do their PhD, there is a word and page limit. So I am doubtful that what could possibly be said in 800 pages that you cannot say in 400 pages, unless there is an element of repetition.
I believe that party submission is submission to the other parties, not to the tribunal. I'm joking. Okay, I'm serious. Don't quote me this in the actual case. But it's quite useful because the other party will know what is the exact arguments of the other party. That is quite important. And the parties can highlight issues to be decided by the tribunal. Tribunal can be assisted by anybody, some assistant, or just he or she can herself review the documents or the key element documents. You normally have a summary, 100-page summaries of the submission. But the point I want to emphasize that students are different. Some students very bright. Once you start to explain, they immediately understand what I'm saying. I don't have to explain more. But some students not that bright, or need some assistance from others, but it's very reasonable. So we have to deal with the issue case by case approach. And then sometimes we have too many things to explain, then you have time to explain, stage by stage. So that's what I was.
John, I see you're anxious to intervene on this point.
I agree with Kevin. It's everything is case by case, but I think page limits are vastly underrated. I mean, if you tell a party they've got 30 pages, it'll take them longer to write 30 pages than it will to write 100 pages. I mean, it's much harder to write something short than something long, but they will boil it down to what they really want you to know. And if you let them go, and it's hard to do that in the early submissions, but by the time you get to, I hate post-hearing briefs, I should say. As counsel and as arbitrator, I loathe post-hearing briefs. I want to bring it to a close at the hearing. I want to sum up. I want to tell the arbitrators what it all means at the hearing and have them go decide. If I'm the arbitrator, if I've heard it, I want to get to it right then. So I don't like them. But if you have to have them, keep them short, and I really think arbitrators do the parties a favor putting page limits on post-hearing briefs.
Janet, let's come to a hot topic, to use a popular expression in arbitration conferences. Secretaries, both institutional and tribunal secretaries. We know that there are different approaches to this in different institutions. What is your view? How can they contribute, if at all, to effective deliberations?
Thank you, Andrea. So I should preface my remarks with the sort of observation that I think that consensus has formed around the idea that secretaries can provide assistance to tribunals in arbitrations, but there are some conditions on that, and specifically that the tribunal secretaries act under the strict control of the tribunal, such that they don't impede or interfere with the decision-making process. I think going back to the case-by-case theme that we've just heard, each case will be different, and I think each case will involve different participation by the tribunal secretary, depending on how the arbitrators, how valuable they think that contribution can be. We've talked sort of in terms of phases of arbitrations so far, and I think that to some extent, deliberations continue from start at the constitution of the tribunal and actually finish at the end of a case, because throughout a proceeding there will be decisions that need to be made, whether they're procedural or substantive. And a tribunal secretary can play a role throughout that process. I see sort of 5 specific categories or elements of a proceeding where a tribunal secretary can contribute. I think the first one is managing the proceeding. So frequently procedural issues will arise for decision by the tribunal, and that can be at the first session or at any time during the proceeding. And the tribunal can be assisted by a secretary, particularly one who brings into the table in-depth knowledge of the procedural rules. Tribunal secretaries can also share their own past experience of procedural issues or decisions and look at how they've been dealt with by tribunals in the past. So really to provide general guidance on best practices with respect to procedure. Secretaries can also help with organizational measures, and I think they have a role in ensuring that cases move forward expeditiously, although ultimately that falls to the tribunal and the parties. They, for example, can ask tribunals to set aside time before hearings to sit down, discuss the issues, and perhaps come up with some of the directions that we've heard are so important in directing deliberations. They can also assist with issues such as setting aside or encouraging tribunals to set aside time and to come up with timeframes for decision making. In preparing for deliberations, I think tribunal secretaries can assist the tribunal members in making the exercise of their functions a little bit easier. For example, they can develop an organizational structure for identifying the issues that are arising in the case. They can do administrative tasks such as organizing files, perhaps assisting with preparatory work, preparing chronologies, organizing evidence, sometimes perhaps preparing notes on legal issues or other issues. During the deliberations, tribunal secretaries can take notes, answer questions about exhibits perhaps, brief the tribunal about how the parties have articulated their cases and what they relied upon in support of their propositions. You'll find that secretaries, particularly institutional secretaries, will have their finger on the pulse of the latest case law. So they can bring relevant cases to the tribunal's attention, and obviously it then falls to the tribunal to raise those cases with the parties if necessary. I think secretaries can provide a very valuable role in acting as sounding boards for tribunals, whether it's about procedural issues or substantive issues. And they can do that within the sort of zone of confidence that is created in any particular case. And I think one other role that tribunal secretaries play is sometimes to provide balance in deliberations. So in a particularly heated discussion, I think sometimes the presence of a secretary can help to calm matters. And finally, secretaries have a role in writing and editing awards. And before I create headlines by suggesting that secretaries should or can write awards in their entirety, I think if requested, tribunals can direct secretaries to draft particular parts of the award. For example, the procedural history, or perhaps a summary of the parties' submissions. And in the course of doing that, secretaries need to be very careful not to take a position on the parties' submissions, but really just to reflect them accurately as they were made. At ICSID, tribunal secretaries, they review the draft awards before publication. I think that's a particularly important role because it ensures they can check them for consistency with the convention, with the arbitration rules, look for gaps in logic, inconsistencies, and really just keep an eye on the post-award remedies and try to make sure that awards are watertight when considering those. And ultimately, I think it's helpful for a tribunal to have another pair of eyes look at an award, be it for checking references or simply just for sense.
So separating arbitrators who are fighting, I think we all agree that this would be a useful task. I think a much hotter topic is precisely drafting parts of the award. But my question would be, is there a significant difference between institutional secretaries and tribunals, secretaries, yes, and the tribunals appointed experts? Or, as I said, we have different approaches in different institutions, although listening to what you said about rereading the award before notification, I think also in a system like the ICC system where there is no role for members of the institution in assisting the tribunal deliberations, but there is, of course, a role as part of the scrutiny process in reviewing an award before it is notified. I wonder whether in institutional system secretaries there is perhaps less flexibility in thinking about the case-by-case approach and the fact that the tasks may be tailored to a specific case, to the needs of the case, of a specific tribunal.
So the functions of the ICSID secretaries are essentially set out in the administrative and financial regulations, which provide for the appointment of a secretary, so an expert who guides a case through the process. And however, I think that in practice, and then we look at the ICC system, and to some extent the roles performed by secretaries in other cases are performed by the legal counsel at the ICC, for example, providing guidance on procedural issues. But I think to a large extent there is consensus across the institutional guidelines on what the functions of a tribunal secretary should be, and also, for example, in the ICA report on secretaries, whether they're appointed by an institution or whether they're an administrative secretary appointed by an individual tribunal outside the framework of an institution, the roles should largely be the same. Although perhaps in an institutional framework where there really is a need to know how past procedure has worked, there may be an added role for experts in that procedure.
Let's come to the actual deliberations. John, any practical tips? We already mentioned the time of deliberations. I started by saying deliberations, stricto sensu, is something that occurs at the end of the case, but correctly, Janet said it's deliberations is something that spreads throughout the case. Time, location, distribution of tasks among the members of the tribunal. Any specific tips?
I think it's important for the tribunal to talk through the case, but it's a little delicate to figure out when to start. And I think it's probably a mistake for the tribunal to engage much on the merits until both sides have been heard from. There's a temptation when the first brief comes in, to sit down and say, oh, okay, it's pretty clear to us where we are. I think it's important to sort of, hold off and wait until you've heard from both sides. From then on, I don't think tribunal members can talk too much. I think you want to start a dialogue back and forth, identifying, well, first, do we all see the facts the same way, or do we see a completely different set of facts? Because, two people can look at the same narrative and see a completely different story. So getting a common sense of what actually has been going on, what is the issue, is very helpful. And then you want to start bringing in, okay, what law are we dealing with? What does it say? What does it require the claimant to show? Is the respondent right that the claim is barred? Whatever the legal issues are. I think if all that engages as you're going along, by the time you come to the hearings, the tribunal members should be warmed up enough to actually put the evidence in that context and start doing their balancing and reaching a decision about who wins and who loses and why. In terms of formal deliberation, it seems to me the ideal time to do it is right at the end of the hearings. Now, of course, post-hearing briefs are in tension with that because you can also say, well, we should wait till we've heard the parties' last, summary of where they are. But it is just hard often to get tribunals back together after a post-hearing brief. And that's one of the merits, if the parties really want post-hearing briefs, of scheduling one more day for final argument, basically postponing the oral argument until after the post-hearing briefs, and then once you've read everything, have heard the argument, then you can sit down and really engage. I think it's treacherous to let it wait and try months later to remember what it was you thought just at that moment when you had it, all firmly in mind. So but timing when to start discussions and then when to really try to close and reach a conclusion can be delicate, and is where a good chair can make a huge contribution.
I guess it's difficult to figure out how much time you need for deliberations immediately after a hearing or the closing of the case.
You can, I think, a good rule of thumb is you always need twice as much as you've allowed for.
Thanks very much. Unless there are other comments from the panel, I think we have a few minutes left for questions from the floor. And please state your name before asking the question. Yes, please.
David Waddell. So I wanted to ask Mohammed about putting together a substantive agenda before the evidence begins, or maybe even at the preliminary hearing conference. How do you avoid what Mr. Townsend just talked about in terms of engaging in a determination on the merits? It seems to me you have panels, somebody's going to say, well, I think we need to deal with this issue. Another arbitrator may think, on the panel may think, I don't think so. Why would you think that? And then you start to get into a little bit of the deliberation. And then one other, with your hidden needle in the haystack with regard to jurisdiction, prior to taking the evidence, I've been involved where we would ask the parties, we're just going to confirm there is no challenge to the jurisdiction before you even get started, and get an affirmative from both parties. I don't know if you think that would cure that problem or not.
Well, thank you very much. Just briefly, my suggestion about a substantive agenda was absolutely after the 1 or 2 rounds of submissions. It's just pre-hearing. It's not definitely at the beginning of the procedure. No one knows. But just pre-hearing. When you have a pre-hearing conference, it is at that time that agenda could be circulated in abstract terms, just to make sure that everyone, the parties, the tribunal, are well aware of the issues that would be discussed or argued. This by no means ought to be restraining from the parties making arguments one way or the other, but everyone knows de facto what the case revolves around and the tribunal's expectation to hear them on these matters, or possibly even add to that agenda from the parties' perspective. But that will give the parties the assurance that the tribunal at least has done the minimal job, that they at least have a perception, not about what to decide, but what the issues are, that they have at least done the preparatory work for the hearing. That's the when that ought to be the thing. Now, the jurisdictional challenge, what happened in that case, was absolutely, I fully agree with you, no jurisdiction objection, everything in the beginning, you ask them. But that has arisen from the subsequent submission made by one of the parties. So the party's final submission was saying that point in that latest submission is beyond the tribunal's jurisdiction. So it was a matter that has arisen in a very late stage, and the council has intentionally devoted just a part of one paragraph to plant the seeds of that for whatever to come in possibly a post-hearing thing. So that was the whole idea.
Kevin.
I have some comments on that idea. I like the idea that we have some issues to be argued in the hearing, but my experience that if we do that, then we have fight about what issues are going to discuss at the hearing. So based on my experience, it's more useful when the tribunal, in the course of the hearing, tribunal have that more clear idea what is the more important issues in the arbitration. So by going toward the end of the hearing on the merit, tribunal can suggest that the tribunal is so interested in these issues received some comments from the parties. By that time, tribunal have better, and everybody have better understanding what this was evidence, what the witness said. So it's a bit dangerous if we try to agree something before the hearing, then we end up with unnecessary arguments or the issues to be determined by the tribunal. Just comment.
Time for a last question. Two, and then we'll have to close.
Hi, Alex de Gramont from Deckard. We recently had a case in which, after the statement of claim and statement of defense were filed, we had a 2-day hearing for opening arguments, but before the reply and the rejoinder. I think I mentioned this to you, John, when we ran into each other on the way to London. And I was very skeptical about it at first because it's very expensive and very time-consuming. But it was incredibly useful. It required the tribunal to really focus on the case at a relatively early stage. It helped us focus the issues for the reply and the rejoinder. I don't know that I would recommend it in every case, but in a really big, complicated, high-value case, I think it's very useful. And I'm not sure if that's a more elaborate version of what you had in mind, Mohammed, and when you would set the agenda of issues.
I think that's a great idea if the parties are willing to pay for it.
Last question.
John Greenblatt. John, on your comment about the post-hearing briefs, I share your disdain for them. I particularly share the disdain for 2 rounds of them. But I do think that targeted post-hearing briefs can be effective, but it requires the tribunal to show its hand a little bit. So if the tribunal, I would prefer as counsel to know what the tribunal is troubled by or wants to know about in the evidence. So-and-so testified as follows. We'd be interested in the party's views on those kinds of things. Otherwise, the concern is you're rehashing the trial, the whole hearing, and you don't know whether the tribunal really wants to read it again. And the second point is really a cost point, which is the more submissions there are, the more the costs go up because we're all trained to, to do these A+ jobs on this as best we can. So I think that in that vein, the more you can do after the hearing when everybody's tired of hearing the case anyway, to limit it, the better we can be. And I'd be interested in your thoughts on that.
I agree with you. I think if you're going to have post-hearing briefs at all, you want to, one, I think they work better after at least some argument or back and forth with the tribunal. And that it could be argument with questions. It could be the tribunal saying, listen, these are the points we're wondering about, but you want something to focus them. And then from the point of view of counsel writing them, if you're going to do a post-hearing brief at all, what you really want to do is have in that brief, preferably in the shortest possible way, the points the tribunal is going to need to put in an award in your favor in approximately the order in which it's going to want to put them in the award, with the citations to where in the record it finds that stuff. I mean, that's the most useful post-hearing brief you can give a tribunal, is basically here guys is the outline of the award we'd like you to render, and here are the points along the way that will support it.
I would add that's not only an effective post-hearing brief, but an effective pleading to begin with.
I just want to add one final thing so that people wouldn't walk away thinking that this panel thinks of arbitrators as students. So I would pose a dissent on that.
I was wondering.
Because to me, students don't mark their exam papers. And at the end, the decision makers and the markers are the arbitrators. So I fully agree with John that you want to make sure that either the arbitrators got it right or there's something lurking in their mind. You're helping by disambiguating that and addressing their concerns. Just walking away thinking that everything is good might not be the solution. So, and to answer to the point, some people get it slowly, or, I mean, you've chosen the arbitrators. You either choose good people or don't, but at the end of the day, that's it.
Kevin.
I mean, it's, whatever we discuss, it should be the practical. We want some ideal words, but in reality it's quite difficult. Many tribunal members just arrive on the day from different hearings, so they have limited time to digest. So that's why I like the idea that's I like the idea that after one round of submission, have opening arguments. I recently wrote an article, a honor room for the John Beach retiring from ICC president. The title of the article is Gangnam Principle. I tempted to say Gangnam Style, but it's Gangnam Principle. That's just the idea that at different stage of the hearing, as the case develops, my experience, at least the Korean experience, is that it's much cheaper and quicker than just one set of hearing for long periods.
Okay, we now have to close. Before handing over to Juliana for some communication, please join me in thanking the members of the tribunal.
So we will have a coffee break until 4:35, then the final panel. And after Meg's conclusion, please join us for the cocktail reception so we can celebrate the good discussions.